What makes a business method patent eligible? Imagine trying to protect a new way of doing business with a patent. What makes some business ideas qualify for patent protection and others do not? Let's break down what it takes for a business method to be patent eligible. First, the invention must fit into one of the four categories listed in the law: process, machine, manufacture, or composition of matter. Business methods are considered processes, which means they have to be presented as a clear step-by-step method rather than just an idea or concept. Next, the invention must be more than an abstract idea. Courts have clarified that simply having a new business idea isn't enough. The invention needs to involve some technological aspect or practical application. For example, a new way of managing data that improves computer performance could qualify. But just a new way of organizing meetings would not. A key test used is called the machine or transformation test. This means the business method must either be tied to a specific machine or device or transform an object into a different state or form. For example, a process that involves a particular computer or hardware component, or one that changes data into a new form, can meet this test. Following recent court decisions, a business method must include a technological element. That means it should involve hardware, software, or a technical process that improves something in the real world. Simply applying a known business idea on a computer without any technical innovation usually isn't enough. If a software method speeds up processing or makes transactions more secure, that could be patentable. The invention must also have utility. It needs to produce a real, tangible result or benefit. For example, calculating a price or optimizing a supply chain are concrete results that show usefulness. A purely theoretical idea or a concept that doesn't produce a real-world effect won't qualify. Another important requirement is novelty. The business method must be new and not previously known or used by others. If it was publicly shared or used before the patent application was filed, it generally won't be eligible. There's an exception if the idea was published within 1 year before filing. The invention also needs to be non-obvious. This means it shouldn't be an obvious step or a simple combination of existing ideas. It must offer something unexpected or a new way of solving a problem that someone skilled in the field wouldn't see as routine. The United States Patent and Trademark Office classifies business methods mainly under the category of financial data processing. This includes processes related to finance, business management, or pricing that involve computer technology. Examples of patentable business methods include online systems that use new technical infrastructure, algorithms that improve digital advertising, or secure e-commerce transaction methods. These involve a technological component that provides a clear technical benefit. Finally, there is a process to challenge the validity of a business method patent within 9 months of its issuance. If someone believes the patent doesn't meet the legal requirements, they can file a challenge, but only on specific grounds. In summary, a business method becomes patent eligible when it fits into the legal categories, involves a technological element, produces a real and useful result, is new, and isn't obvious to someone in the field. These rules help ensure that only genuine technological innovations in business processes receive patent protection, not just basic ideas or routine applications.